Doug Rohan of Rohan Law joins us now. And Doug, you've done a lot of, for a case you're not on, you've done a lot of work on this FSU versus ACC and the offshoots of it. Obviously, Clemson's involved in this now, and I'm sure that we'll see UNC eventually if half their boosters get their way. But what is the newest filing, and what changed from the original one, because they were told that they had to kind of revise what they were arguing against the ACC?
Awesome. Well, I appreciate you having me on. It's fun to be on here. You asked about 3 different subtle questions in your intro, so I appreciate that. I was accused of being a grifter on one of the other YouTube channels today. If so, I'd like to know where they're sending the checks, because they have not come to my office yet. I'm doing this out of a labor of love. I love the law. I represent clients in Atlanta, Georgia, and I love breaking down the law for them and easy to digest and understand pieces. And so I also love Florida State. I'm not going to lie. I am a homer. And if somebody wants to discount me because of that, then that's fine. I'm not here to blow smoke up everybody's butts, but I am here to provide a perspective of where this bus has been. I'm not going to tell you where the bus is going to go, because that's beyond my capacity and my experience. But I'm just trying to break down what is happening in a way that our fans can understand and know what the terms mean, what the process means. And so, yeah, it's fascinating to me. What we're at right now is a second amended complaint that Florida State filed this week. And what they've done is they've started over basically from scratch, incorporating some of the things that they learned from the first hearings and some of the things that they learned from the Clemson filing.
So, by the way, also a homer as well. So I've been accused of that many times. We'll be in solidarity together.
Excellent.
So, no, but in this, there's a lot of, fire and vitriol from the FSU side of, fans about this and about leaving the ACC. And we were talking about just before you came on about, they were going to do this anyway, whether the playoff thing happened or not. That just put a little more hot sauce on it. So there's been a lot of interest. What is Florida State's central argument to that the grant of rights is not beholden to them forever?
So it really is fascinating. And people who are upset about this, or who are, saying you signed the contract, you just got to live with the contract. Well, you're discounting an entire area of practice that is designed around determining what is valid in a contract. What does the contract say? So this is very routine and very common. Of course, we all heard the news reports when the contract was signed, and we've seen the headlines from various writers over the year about this being ironclad and about this being an irrevocable grant of rights. But once you actually look beyond the first line of the document and actually look into what the words say, they matter. And in this particular case, the grant of rights, in the first paragraph describing the grant of rights, names ESPN specifically 9 different times. And so what that means is that we right off the bat have a limited grant of rights, and that is it grants the ACC the rights of each member to negotiate with ESPN. So if we don't have ESPN in the picture, there is no grant of rights. So that right there is objectively clear for everyone to see. It's not negotiable. What the further arguments are, we could get into a little bit later, but that should make everybody stop and take a look and realize maybe those things that we've been told over the last 10 years are not true.
What is there? There's no obviously smoking gun, otherwise that would be kind of over. But what is the likelihood that there are things that Clemson will find, because they get to see the TV contract, in its entirety, that will help both these sides navigate their arguments?
So what we have in the second amended complaint from Florida State and in the complaint from Clemson are allegations. These are simply statements from both legal counsels to the judge. This is what we intend to prove in this case. So you're right. Those aren't evidence. That isn't the end-all be-all in proving your case, but attorneys are very careful to try to not overstate what evidence they have. Both parties have seen the ESPN agreement with the ACC. It wasn't included yet as an exhibit in either of the documents, so we, Joe Public, haven't seen it, but the attorneys have. And so I can have a little bit of confidence in the recitation and the statements of both the attorneys that essentially what they're saying is, look, we've already talked about this first part. ESPN is the linchpin to the ACC's grant of rights. The grant of rights allows the ACC to do whatever is necessary to fulfill the ESPN broadcast agreement. Well, I'm suspecting that what we're going to learn is that ESPN agreement is written in such a way that it allows ESPN to broadcast ACC member games, physically home games. Well, if that's the extent of the language, if there's no other language in there, then Clemson and now Florida State are arguing we can leave the ACC. And once we leave the ACC, ESPN loses the right to broadcast our games. And as soon as ESPN loses the right to broadcast our games, it's not a requirement for us to fulfill the grant of rights, because the grant of rights is only to do those things that the ACC is required to do in order to broadcast games on ESPN.
Is that something that a judge will buy? I mean, that
again, we have to see the ESPN agreement before I can opine, that far, state that strongly. But that's what's being argued, and it certainly makes logical sense if the evidence supports those statements.
Why would it be important for, outside of the trade secrets argument that ESPN has made, and for the ACC to maybe not go back and see some of the ways that things were done, particularly on the Raycom end in this television deal? Why is it so important for those things not to be out in the record for them?
So I was at the North Carolina hearing in Mecklenburg County the first time this came up back in, I guess it was April, back in April. And the ESPN attorneys were there at the request of Judge Bledsoe, and they made a very strong argument. First off, this agreement has never, ever, ever in the history of ESPN been made public. And that's important because we see a lot of headlines about what these deals said, but those deals or those articles are always couched on, based on anonymity or based on a promise not to disclose the source, or it's alleged to be worth $3 billion in the new SEC contract. We don't actually see the agreements. So there is some validity in saying, look, we're negotiating certain details with certain partners. If Fox were to get this information, if Apple TV were to get this information, they would have a competitive advantage over us. Now, they call it trade secrets because that's what the exception is to the public disclosure. So they have to call it trade secrets. But really what they're arguing is we don't want the details of each of these deals coming to public light. So that's what ESPN is trying to protect against.
Doug, I'm the moron on the show when it comes to the legalese stuff. So you're fascinating, and I love listening to it because I just learn a lot. One of the questions that I've had that I hope you can clear up is with the kind of the dueling lawsuits, how does that work from a timing perspective in terms of, like, if one finishes before the other, is there an importance to one finishing first as opposed to another state? Like, can you kind of clear up just with those both ongoing, if it matters timing-wise, which one happens or how that kind of all occurs?
So first, we're looking at the two lawsuits of Florida State and North Carolina, or Florida State and the ACC in North Carolina.
Right.
Between those two, obviously, both parties believe their home state is an advantageous area, locale to have the hearing. What Clemson does is it introduces South Carolina to the process, which also doesn't have the sunshine law complications that exist in Florida and are currently one of the things that is slowing the Florida case down some. So between North Carolina and Florida State, if one of the courts of appeal or Supreme Courts doesn't decide that this should be in the other state, then yes, both states are on a race to the finish line to see who finishes first, because under the Constitution's full faith and credit clause, whatever decision or judgment in one state must be then respected by the other state. But then you throw in Clemson, who's not a party to either the North Carolina or Florida lawsuit, and you simply have a third party that is trying the same issues, the same themes to perhaps a conclusion in a third state. What's going to happen there is that whatever happens to the lawsuits for Clemson or Florida State is largely going to be reapplied to anybody that is interested in leaving. That's how it's most likely going to play out.
Okay, so that answers, I think, my other question, which was, it wouldn't be necessary for anybody else like North Carolina now to like jump into the fray or somebody else. Like, you can kind of just sit back for these other members and just watch these play out, right? And you'll have your answer rather than applying any other external pressure.
Well, we saw the articles that came out yesterday from one investigative journalist talking about the tax implications of all the ACC championship games and contests taking place in North Carolina and their tax breaks. So that has to be a third metric that's included in deciding what's going to happen with North Carolina. But you have their internal squabbling where they don't really know who's in charge. And then you add to it a second complication of not having the money. They just reported a $17 million deficit last year. So North Carolina, on the one hand, probably would like to just sit back and watch and see what happens. But let's marry that position with what was coming out of Amelia Island in the last meetings and the suggestion that the ACC has no motivation to settle. If the ACC doesn't want to engage in any settlement negotiations, then it would behoove North Carolina to start the litigation process, because that will then add pressure to the ACC to resolve this on a more timely basis. The parties have the right to settle the dispute at any point, though I suspect that's probably more likely after the season starts. But a litigation of these issues, the true lawsuit going to a jury, going through the entire process, you're talking about probably 2 or 3 years before these cases come to a judgment.
That being said, are they, outside of the time, are they just motivated in that, going any kind of discovery in this case, obviously for the ACC and ESPN is something they don't want to do, especially if they lose that part of it, and the agreement can become public. And just for Florida State and Clemson, that there might be some things that come out that don't make them look all that great in this process either, that this does wind up with a settlement that's palatable for both sides?
Well, it's actually going to be a settlement that's not palatable for both sides. That's when you have a successful agreement. When nobody is happy, that's when you have a true outcome that is typical. What needs to be determined by the ACC is not what's going to happen in the next 5 years, but what's going to happen in the next 20 years. That's the question they need to answer. If I was advising them, if they asked for my opinion, or if I was one of the attorneys in the boardroom, Clemson and Florida State are out the door. So what are we going to do about that? Do we pocket $200 million, $300 million from each one and share that with our remaining members? A, we've made the price tag so high that nobody else can afford to get out. B, we've mitigated the damage of losing our 2 major football players, knowing that our ESPN contract is going to be for substantially less. And 3, let's focus on being the premier basketball program or institution that the ACC has been designed to be from the beginning. Nobody in the program, in the conference, took football seriously. They brought Florida State in thinking that would elevate all the other teams. And what has Miami done in the last 20 years? Nothing. So obviously the tobacco road schools did not want to invest regularly and routinely in football. So give up the ghost and just become the best basketball conference possible with several $100 million in your bank account.
What do you think? Is 200 million the number? Is that a palatable number for those two? Or I believe so. I don't know. I have talked to the athletic director. I've talked to the booster president. They haven't told me anything other than high five, keep it going. Mm-hmm. I don't have any inside information. I don't know what they're going to want to do. But if the risk is stay in the conference to drag this litigation out 2 or 3 years, the math works for anything under 300 million. Now, if the number is 300 million, then obviously it's a wash. So you want it to be something less. But basically over the next 10 years, if there's a $30 million difference in pay, then that's where the number is at about 300 million. Now you add to that the college football playoffs now, you add to it this getting hosed by, or not hosed, but the agreement for the House litigation. Mm-hmm. The numbers
grow exponentially very quickly. So I think the math works for Florida State to pony up 200, maybe even 250 million for the opportunity to be out sooner rather than later.
And then is this where private equity comes in, or private
it's
capital?
An interesting development. Yeah, it's an interesting development. I don't know what their expectations are. I mean, look, Florida State has had to retain their coach and pay a premium. They had to promise to invest in several ways to keep Coach Norvell, in addition to the football-only facility that they've already broken ground on. They're in the middle of a stadium remodel. So Florida State already had some pretty hefty, high price tag items in their shopping cart to begin with. So I think that's where the private equity is going to have to come in if they want to move along and expedite this process. Of course, the settlement can include payment over 10 years or 5 years or anything that is, again, agreeable by both parties. But it certainly seems that that's what they've been setting up for the opportunity to do.
It is. What, Doug, just your opinion. I'm not again, we have no idea where they would wind up. Really, we know where the two options that they're going for. But where do you think those schools would be best wound up, or do you think what is the real option for them?
Before the college football playoff snub, I would have said that ESPN and the SEC would have been the best option. That would make sense for ESPN to protect the territory, keep Fox out of the South. ESPN would get to keep the package family of Clemson and Florida State, just move it from one conference to the other. But I think there's a lot of bad blood for how all of that went down and for Florida State being left off the playoffs. So I think there's a lot of people that would rather see Fox take over and have us on that big noon Sunday game that's being broadcast out of Penn State, to start the 2026 season. It's, 1A and 1B at the end of the day. I would prefer personally for road trips to have Ole Miss and Arkansas on the schedule. And as a season ticket holder, I would love to be having, Alabama and Tennessee come to Doak Campbell Stadium. But if it's a matter of getting out, and we just saw the numbers this week, Big Ten actually grossed more than the SEC did. Just get me in one of those two. I really don't care at this point.
Speaking of road trips, are you going to make the road trip to SMU?
No, we are going to Ireland instead.
Oh, wow.
I would have liked to have gone to SMU, but Dallas is a neat place, and I think you're going to get a lot of Seminoles out there. Frankly, of the three editions, I think SMU is going to be the tougher of the three games. I would put that right now fourth in the list of tough games on Florida State's schedule in the coming year. Yeah,
no, I would agree with you. We're 90 miles away, so I'm going to that one. So, but yeah, I was hoping we could link up there. I have not been able to wrangle Ireland though, so I wish I could. But yeah, Dallas is wonderful, but again, there's no Blarney Stone, so I get it. Doug, thanks so much, and love to have you on again as things develop over time.
It's my pleasure. I don't think this is going to be going away anytime soon. So let me know the next time you have some important questions, and I'd love to hop on with you guys.
Yeah. Great stuff, Doug. Appreciate it. Talk to you soon. That's Doug Rohan Law there, and who broke it down. And he simplified it because, again, this stuff is really complicated. So interesting to see.